presenting is the defense of infancy in Malaysia, a comparison with the Shariah Principles. To start, in Malaysia, there is a rising number of cases of crimes involving children as the perpetrator. Based on the research, the number of crimes involving children are 3,700 cases in 2012. Meanwhile, there are 7,816 cases in 2013. In both of these years, the highest number of arrests involved those between 16 and 18 years old. Section 2 of the Age of Majority Act 1971 states that a child reaches the age of majority when they are of 18 years of age. Section 2 of the Child Act 2001 explains that a child is a person under the age of 18 years of age, and in relation to criminal proceedings, a child is a person who has yet to attain the age of criminal responsibility as prescribed in Section 82 of the Penal Code, which is 10 years of age. The defense of infancy works to protect a child who is still in their developmental stage from the damage that might embroil from the criminal justice system. The rationale of the defense of infancy is because a child under a certain age is deemed to be on the presumption of dolor incapax, which is incapable of doing wrong. This presumption is recognized by the Malaysian Penal Code. Historically, this defense was created to prevent children from being exposed to the same punishments as adults. In Islamic law, it is no different. It provides an exemption of criminal liability for children of a certain age. In Shariah law, an infant is free from any criminal liability. An individual is regarded as an infant from a period from birth to Mumayyiz, which is the age of discrimination. The exemption of infant from criminal liability is derived from the hadith of the Prophet, which states that 3 people that are exempted from the punishment and religious accountability are infants until he attains majority, and an insane person until he is sane, and a period who is asleep until he wakes up. The objectives of this assignment is to analyze the different approaches between the civil law and the Shariah Principles on the defense of infancy, and to measure the differences of the coverage of civil law and the Shariah Principles on the defense of infancy.
Today, I will talk about defense of infancy in Malaysia. Under the Penal Code, there are 2 defense of infancy. First, nothing is an offence done by a child under 10 years old. Second, nothing is an offence done by a child above 10 and under 12 years old, if they have not gained enough understanding and not mature enough to know the effect of their action may be considered as an offence. However, if the child mature enough to understand the effect of their action, they may be liable on their action, as in the case of Lim Hang So versus Public Prosecutor, where the court dismissed the appeal made by that child because he had knowledge. According to Child Act 2001, if they are children who commit a criminal offence, Court for Children has the jurisdiction of it because the power to decide or cast out any allegation towards children relies on them. But this court does not have jurisdiction if the punishment of the offence is sentenced to death. This act also helps on giving the guideline on how to deal with the charges against children. Child Act 2001 and Court for Children both will be used to protect children. While for common law, it applies doctrine doli incapax as defense of infancy. Doli incapax is a term in Latin which means powerless to do an offence. There are 2 presumptions under it. First, a conclusive presumption, where a child under 7 years old will be assumed powerless to be found guilty on their criminal action. The finding is irrebuttable. Second presumption is irrebuttable presumption, where a minor between 7 and 14 years old will not be considered committed any offences unless it was proven that the child is not only misbehaved but they has knowledge that their action was wrong. The age limit has been raised from 7 to 10 years old, and Malaysian law followed that. Lastly, for Evidence Act 1950, the Act protects a child, especially boys, where a boy under 13 years old cannot be assumed to commit a rape, and this finding is irrebuttable.
Today I'm going to explain about the defense of infancy according to Shariah Principle. According to Islamic law, a human ability to discharge duties and also commitments of Allah differ in status, adult or infant. Adolescence begins from the age of discrimination to the age of maturity. Adult is liable, accountable, and also responsible for his act. Contrarily, an infant is free from liability as far as Islamic law is concerned. The Holy Prophet said that 3 persons are not accountable: a child until he reaches the age of puberty, a sleeping person until he wakes, and an insane person until he became sane. Imam Malik, Imam Shafiq, Imam Ahmad opined that whether male or female, a child became an adult by reaching the age of 15 years. But according to Imam Abu Hanifa, a female child becomes an adult by reach the age of 17, while a male by reaching the age of 18 years old. In this regard, the elementary principle in Islamic law towards juvenile offenders are: there shall be no crime without law, there shall be no punishment without law, there shall be no retroactive punishment without law, presumption of innocence unless proven guilty, every person has the rights to protection of life, liberty, and also puberty, and finally the rights to a fair and liberal trial from impartial judge. Thank you.
Assalamualaikum and hi. Today I will talk about comparison analysis between civil law and Shariah law. The first comparison is involving burden of proof. According to the Malaysian law, burden of proof for defences against infancy is rely on the accused or the defendant. For instance, the defendant must prove there is no existence of menstruation. Meanwhile, burden of proof against infancy for Shariah law is beyond a reasonable doubt. Whatever proof or doubt that related to the fact of the case will consider questionable in order to prove the claim. Next, referring to the different age of majority, Malaysian law has set down the guiding principle of the age of majority, that is at the age of 18. Below that will be considered as minor, while Section 82 in the Penal Code stated, which is nothing an offence which is done by a child under the age of 10. This can be seen in the case of Public Prosecutor versus Hidayatul Akmal Azman in 2020. For the age of majority in Shariah law is referring to the Shariah Criminal Offence Federal Territories Act 1997, referring to the attainment of puberty. In Islamic law, puberty is called baligh. The general definition of baligh is referring to a child who has attained the level of maturity and know the nature and the consequences of their action. Same goes to Shariah law. The specific punishment and corporal punishment are all applicable regards to the punishment for an offences for a child. Lastly, in the term of punishment, in common law, the possible punishment for an offences against child is imprisonment.
There are pros and cons in defense of the infancy, which are to protect the children because usually children cannot distinguish between right and wrong, and also to protect the children because commonly children cannot establish menstruation in committing the offense, and children tend to be manipulated by the adults. And lastly, to protect the children because children always incapable in committing the crime. Meanwhile, for the cons, it encourages children to deceive the adult. For example, like taking advantage in the case of contract, such as the children can commit fraud and misrepresentation. Secondly, it causes the children to lose the accountability and degrade moral values of the innocence of the children. And last one, it contribute the bad image for the children if the children are being said guilty and also being sent to the juvenile center.
As conclusion, defense of infancy in Malaysia are still being recognized and being practiced broadly in Malaysia. Doesn't matter in civil law or Shariah principle. Even though there are two different approaches to analyze the defense of infancy, at the end, the purpose or the objective is still the same, which is to protect a child from being misjudged or punished in wrong punishment.
Now I'm going to explain about the recommendations. Islamic criminal law has its own advantages compared to common civil crime laws coming from Western countries. The criminal law that exists today proved to fail to eliminating the crime. Law enforcement in Islam will bring success not only in the world but also success in the hereafter. Islamic strongly recognize the rights and positions of each person. This matter is of interest everyone individuals to get their own privilege without harming other individuals and also including children. Thank you.